Hi, thank you for that introduction, Stella. It was very flattering. And thank you to Genspect for having me today. I am going to speak about fighting censorship at school. In 1791, a new nation ratified a Bill of Rights. Item number 1, Congress shall make no law abridging the freedom of speech. This was drafted a few years earlier in Philadelphia by the founding fathers of the United States. Fast forward, 1996, another group of founding fathers gathered in Houston, Texas, and they drafted the International Gender Bill of Rights. Item number 1, it is fundamental that individuals have the right to define their own gender identities. These two world historical documents are impossible to reconcile. If you want to stop other people from defining your gender, whatever that is, then you must get the state to censor them. But the US Bill of Rights forbids that. Only the United States Supreme Court has the authority and the power to declare which of these bills must prevail, but it refuses to do so, leaving Americans to fight it out. And the real foot soldiers of this war are America's public school children. Under the US Bill of Rights, they are entitled to speak freely about gender and share their opinions about it. But teachers keep imposing on them the International Gender Bill of Rights. Today, I'll show you how those clashes are playing out around the country as we all wait for the United States Supreme Court to finally weigh in. Before I get into the cases, I'll just give you a little bit of legal background that you need to know. So when students are at school, public school, they do not have the exact same level of constitutional protection that they do when they're, out in a park, say, but they do have a lot. So the rule that schools have to follow is they may ban speech that is, quote, disruptive. That word is not a blank check to schools to censor whatever they want. They need to provide a good reason to the court, concrete, specific reasons why they think that some speech might be disruptive. The foundational case here is called Tinker. It's from the Vietnam era when kids wanted to wear black armbands to school protesting that war. That was a hugely emotionally fraught action back then because, of course, kids had older brothers who were serving in Vietnam. Young men in the community had died there. But the Supreme Court ruled that kids should have that right anyway to wear the black armbands of protest. And the reason why the Supreme Court grants kids any rights at all in school instead of trampling all over them and saying, well, you're kids, we don't care, is because actually they think that schools, public schools, are the nurseries of democracy, meaning that we want our kids to learn how to debate, how to run into ideas that make them feel uncomfortable, and how to survive that. So we think that is good and healthy for a democracy. Another way that the Supreme Court has put that, in 1972, I like this one. They said that schools must play a central role in preparing kids to recognize the demagogue. I love that because if there's one thing that I learned in public school, it's what a demagogue looks like. So another key point is that schools must ban speech that is really severe and targeted at individual, like super offensive, objectively speaking. So this is the category of sexual harassment and hurling racial slurs at people. That cannot be allowed in the school, and that sounds pretty clear. But now, of course, we have some people arguing that when a student uses a pronoun for somebody that they don't want to hear, that rises to the same level of harassment as something that's sexual or a racial insult. So that's what we're seeing now. Right. So now we can talk about the cases. Girls' sports, we had the perfect segue to that just now, so thank you, Mariah. All around the country, schools are making girls compete against boys in sports. Their girls and their parents have feelings about that. So I'll talk about three of these instances that have turned into lawsuits so far. I'll start over here in California. We'll talk about this line of kids who are lining up wearing Save Girls Sports t-shirts. That's in Riverside, California. Just last year, the school let a boy onto the school cross-country team. And so, of course, this displaced other girls. Not only that, but they were letting him have special privileges. He was missing practices when girls weren't allowed to miss practices. And so they were upset, and they wore t-shirts to school to express their dissent from that, which said, Save Girls Sports, or XX does not equal XY. Teachers punished them for that. They censored them, they gave them detention, and they told the girls that this speech was the equivalent of wearing a swastika to school in front of Jews. So the girls sued. This was last November. Already they've had a victory because about a month later, maybe less, the school started allowing them to wear the shirts to school. They're wearing them every Wednesday. And we don't know, maybe this is because of the lawsuit. Maybe it's because hundreds of other students had joined them. So they didn't really fit in the detention hall anymore. Not only that, but neighboring schools had also, the kids had started protesting there. It started spreading through Central California. So good for those girls. Their lawsuit is still going on, both for their free speech claim, also claims related to religion and sex discrimination. But they've already had that moral victory. Next, we can move up to Oregon. So this is the picture with the girls standing on the podium and a boy standing on a podium and two girls standing next to a podium. Because these two girls decided, after they had placed very highly at their state competition in Oregon, so this is the state meet last spring, they worked really hard. They should have been number 2 and 3, they were ranked 3 and 4. They decided to politely express a protest by not climbing onto the podium for the award ceremony. They had also worn Save Girls Sports t-shirts earlier in the day. The officials could not stand that. As you can see in the photo, a league official is glaring at them and pointing, go away. So they were kicked out of the award ceremony, not allowed to participate. They didn't get their awards on time. They were left out of the awards photos as well. So they filed a suit. This is a very recent one, just in July. Not much has happened yet, except that the league, so they sued the Oregon Schools Activities Association, OSAA. OSAA has already done one thing, which is they tried to censor the complaints that the girls filed in court. So this is, the girls, one of their claims related to free speech was that the league had engaged in viewpoint discrimination by expressing other political ideas, but suppressing this political idea about girls' sports. So that is a big no-no in First Amendment law. You can't have a government agency or operation choosing which viewpoint. It's like all or nothing. So that's one of their arguments, pretty good. In the course of making that argument, they cite the league's support for Black Lives Matter. That's one example of the league supporting one political idea. So the league reacts to that by filing a motion to strike, which at this stage is kind of unusual. And this motion to strike objects to the girls citing Black Lives Matter because the league says, Black Lives Matter is a divisive topic amongst Americans, and relating the league to Black Lives Matter serves only to stoke outrage. So to recap, they're not recanting their support for Black Lives Matter. They're saying, oh, we'll just try to censor these girls from saying we support it in court. We'll draw more attention to the whole thing by filing this weird motion. Also, this is part of their defense against the accusation that they are censoring girls. So I just want you to understand how the censorious mind works. This is how it works. So good luck to those girls in Oregon. Next, we'll go across the country to New Hampshire. So these are some parents, and the photo we're talking about is up in that corner. You see some parents wearing pink armbands with XX marked on them. That's because their daughters are being forced to compete in soccer against a boy. So the parents attended a game wearing these armbands, and the school district officials kicked them out. They said these bands were hateful and exclusionary and anti-trans. And they weren't allowed to come into the game. So the girls sued, the parents sued. And that case is further along. So they had their argument already in the Federal District of New Hampshire. The decision came down. The judge said that those armbands, quote, can reasonably be understood as directly assaulting those who identify as transgender women. So yeah, okay, you get it. That's legalese for words are violence. The parents filed an appeal, so that is going to the First Circuit Court of Appeal in Boston. The argument is on November 5th. It is going to be a bloodbath. The First Circuit right now is stacked entirely with Democratic appointees, which unfortunately we know what that means. There might be a Trump appointee finally confirmed soon, but that's what it is. They've specifically made a bunch of very outrageous rulings in the trans space. One of them is a precedent in this matter, which basically says that any kind of acknowledging of a two-sex theology, whatever the ideology that we all violently hold here, any reference to it is basically a form of harassment or disruptive speech. So that will happen on November 5th, and I'm hoping that it ends up at the Supreme Court eventually. Next, the most important subject in the world, pronouns. So schools around the country have been enacting policies that limit how students use the word pronouns, and I don't mean due to grammatical concerns, it's for gender theory concerns. So the rules, they have different kinds of wording, but they all say that you're not allowed to use pronouns for somebody that they don't want you to use. So the question is, is it disruptive to call a boy if he wants to be called a girl? Is it harassment to refer to him as he, him? There have been a smattering of lawsuits throughout the country, some of them with positive outcomes already, some settlements at early stages, some good decisions. I'll talk about a few that have risen the highest. So one is called Linn-Mar, came out of Iowa, and it was decided in the Eighth Circuit. So there, the court found that, there seemed to be a free speech concern implicated at an early stage of the lawsuit, and so the school district settled. Another one is Meriwether, which came out of Ohio and was decided by the Sixth Circuit. Meriwether is a little bit different from what I'm talking about here because it was a professor at a university who brought the claim. So not directly on point, but really key point, the court found that all these pronoun issues are political speech. So the other side is trying to say it's trivial, it doesn't matter, therefore we're allowed to regulate it. And the court said, no, that doesn't make sense because you're making a really big deal about it. So we think that's a hint that maybe it is a big deal, it's political. Political speech receives the highest level of protection from the courts. So that is a good precedent to have. And that leads us to the one big case that we're waiting for a result on right now, also in the Sixth Circuit, so Meriwether matters. This one is called Olentangy. Same deal, pronoun code, people challenge it. An interesting thing about it is that the ACLU filed a brief. That is exciting because historically, the ACLU was America's premier defender of free speech rights. They've ceded that ground just a bit last couple of years and taken an interest. They've taken an interest in the International Bill of Gender Rights, and so there's some conflict. So, I was really excited to see what they would say in the brief. And what they do is they say, we don't like either side here. We think both sides are wrong. We don't like the kids who say that you can never regulate pronouns, because we think sometimes you can, constitutionally. But we also don't like the school because we think that their rule was too broad. Okay, so what would a good rule be? ACLU will not tell us. What sort of pronoun use constitutes harassment in their view? Not clear. Don't know. They just kind of tap around. They talk about some precedents, I'll give you I'm not going to go on a tangent about like what makes a good brief, because like, but I'll just give you a line from theirs. They say, "This court should not embrace the view that the First Amendment grants students carte blanche to intentionally misgender." So I will unpack that because some of it's in a foreign language. Carte blanche sounds very exotic, foreign to our culture, decadent, sinful. It actually means freedom. Misgender, when you translate that to English, means calling a boy a boy. I believe that American public school kids do have the freedom to call a boy a boy. We will find out any day now what the Sixth Circuit thinks. Right? It's relevant. It's relevant. So now we are back in New England, unfortunately, which is the pit of hell for free speech lately, which is very sad for me. But and we're talking about a teacher. So teachers have rights too, not so much in the classroom, but when they are out of the classroom, when they're at home, out in the world, they do have free speech rights. The legal test is a little bit different from what I've been talking about. It's a balancing test. So on one side, the court's going to look at, well, what kind of speech is this that the teacher is engaging in? Is she just like, complaining about her boss for some petty reason, or is she talking about politics? Remember, politics are like the most protected type of speech. So that's one side of the balancing test. It's called Pickering, by the way. And the other side is, how disruptive is this speech to school? So that is kind of the same element we talked about earlier. So courts are going to be balancing those two things. So let's talk about what this teacher said. This is Carrie McRae in Massachusetts, about an hour outside Boston on the coast. So she is, she's a math teacher, basically. And in her free time, she's not very online. She's a grandparent. She has a TikTok account, which she uses for a few little things, including liking or reposting other people's memes. And these tend to be like conservative type memes, jokes, whatever. You get the idea. I gave an example of the trans one here. So this image is a man named Admiral Rachel Levine. At the time that Ms. McRae posted his photo, he was an official at Health and Human Services, a trans-identified man. And there's a quote here, which is a fake quote. I don't want to get sued, so it's a fake quote she has. I am an expert on mental health and food disorders, says the obese man who thinks he is a woman. So that's the language. It's not very nice, but it's political. So she's doing her job. Some kids, some very young adults alert the authorities that this woman is on the loose. And these young adults are not connected to the school where she teaches, but like word gets out, like the media gets involved because again, in New England. So it's like, oh my gosh, what's going on? The school, there's like, we're gonna investigate. They run an investigation. They find out that this woman, Ms. McRae, has garnered 0 complaints from her students, uses preferred pronouns for her trans-identified students, and like there is no story here whatsoever. And the only disruption is that a bunch of interlopers came in and made a lot of noise and called the Boston Globe. So this goes to, so they fire her, she sues, she loses in the district court, she goes up to the First Circuit Court of Appeals, again in Boston. Remember what we're talking about. On one side of the balancing test, you have political speech, clearly political speech. All of her memes were political stuff. So it was like the most protected speech in the world versus disruption that was completely fake and manufactured when none of her students had a problem with her. So you would think that Pickering test might hand her a win, but she does not. She draws an L from the First Circuit. And part of the decision, which is a weirdly snarky decision, but anyway, I'll read you the quote that I found distressing. So her memes comment upon hot-button political issues in a mocking, derogatory, and disparaging manner. The meme about Dr. Rachel Levine was clearly insulting and disparaging. Now, there aren't any rules saying like satire is less protected. That's not a thing. The court cites a case which does not say what they say it does. It's kind of a Jason Rafferty move, if any of you guys get the reference. And so, but that's the decision. So she appeals to the Supreme Court, and unfortunately, just this past spring, the Supreme Court decided not to hear the case, but silver lining was one of the justices, Clarence Thomas, issued a statement where he reacted to the entire opinion, calling it, quote, deeply flawed. And then as to that satire piece specifically, he cites 5 different authorities saying she's wrong. And he says the tone of her post shouldn't bear on the First Amendment analysis. And this is a quote from another case he gives: humor, satire, and even personal invective can make a point about a matter of public concern. So it's great to see him do that, but unfortunately, that First Circuit ruling is still there. It's still the law up in those New England states. So if you live in Maine, Massachusetts, New Hampshire, Rhode Island, or Puerto Rico, then your jokes are less protected than your blowhard neighbors' dry, tedious, sanctimonious lectures. This is why I do not visit my family in New England anymore. So I'll just give a recap. Major questions about free speech are totally up in the air right now. It's a really exciting time. Questions like, what is harassment? What ideas are too disruptive for a public school? Should we tolerate personal invective by government employees outside of work? I think the Supreme Court will finally answer these questions in the next 5 years or so, and then those decisions will rule America for generations. And nobody is shaping the outcome of these controversies more than kids arguing with their teachers. Like one question? Was there somebody? Oh,
yes.
Ah.
Oh, stand up. Oh, good Lord. Thank you, Glenna. That was very interesting. You and I are both New Yorkers. I am curious about how to navigate something you didn't talk that much about, which is when the male teacher has she, they pronouns, and your 16-year-old is asked to use them, and our New York State Constitution protects gender identity. Our DOE has a bunch of us on a wanted poster, and the children, you said it's going to be led by children. Even our budding little TERF children do not want to be the ones to call the teacher he. So I would like, or anybody, someone tell me what to do. Thank you very much. I'm not talking about anything specific, except I am.
Well, I'm happy to tell you exactly what to do while the cameras are running. I will say, first of all, New York Constitution, the whole idea of gender identity protection is a paper tiger, the way it's spelled out in that Constitution and a lot of other places. It's incoherent. Do not fear any language about it. Never says what they say it does, but I'll send you a post on that. And then as to kids, I mean, yeah, they are in a tough spot, and I don't mean to order kids to stand up to teachers. In my opinion, they do have a First Amendment right to call a man a man. That's my opinion. We got to wait for, we're in the Second Circuit. It's not as bad as the First Circuit. So your kid might not receive the same lecture that they did in the first. But yeah, it's a hard situation. If somebody out there wants to challenge it, great. Also, I mean, parents could try their hand. If they don't want to use their kid, put their kid in that situation, then parents could maybe get themselves into a pattern such as those New Hampshire armband parents where they have standing to sue. And that's a very exciting idea, so we can definitely talk offline about that.